Welcome to Law for Life with Georgia.
Welcome to Law for Life with Georgia, where attorney Georgia Konstantakis brings nearly 3 decades of Wisconsin legal experience to help her community stay informed, protected, and prepared for whatever life brings. I'm Shameika Rhymes, and today we're talking about what happens when someone passes away without a will in Wisconsin. Georgia's going to explain who inherits, how the probate process works, and why leaving these decisions up to state law can create surprises for the people you care about most. Welcome back, Georgia.
Well, thank you for having me. It's good to be back.
Georgia, a lot of people assume everything will automatically go to their spouse if they pass away without a will. So how does Wisconsin law actually decide who inherits?
Well, that is a great question. In the state of Wisconsin, if you don't have a will, it's as though you died intestate. So what that means is no will, and then the courts will look at an heirship of who is married to who, what kids are involved. So for example, say we have a situation where you have a husband and wife, and all the kids are from that marriage. The spouse would be the one to inherit 100%. Okay, because the spouse survived the children. Now, if you have a situation where some of those kids are not part of the spousal relationship, so say those kids are from a blended family, all right? In that situation, it would be split 50-50. And a lot of people don't know that. They just assume that it's just going to go to my spouse anyway. What do I care? You should 100% consider making a will out and making sure you have listed those who you wish to benefit. So really important to decide. And who decides? It's basically the laws of intestacy. So that is really the determination.
Well, what happens if someone dies without a will and they leave behind a spouse and children?
Well, like I'd said previously, what would happen then, the deceased spouse, if they, again, the scenario is the example that I just gave. If you have a spouse and the spouse, those children all are from that same spouse, then the spouse would their interest would trump the children's interest. So, but in a blended family situation, it is not the case. Again, we've had really nasty knockout, drag out fights because the spouse can't understand in a blended situation that she's sharing 50% or he is sharing 50% of the assets. So you can kind of picture this scenario of someone, for example, is not on the title to the house. And this scenario actually did happen where the spouse thought that she was listed as the joint owners with rights of survivorship, and that wasn't the case. And boy, was she shocked after she had paid off that mortgage, and 6 years down the road, calls the mortgage company and says, "Hey, where's my satisfaction of mortgage?" And she's like, they're like, "What are you talking about? You're not listed on the title." And so she had to go to probate in order to get her name on the title. And she had to buy out 50% of the interest of the 2 children that weren't even her children. So quite the shocker, to say the least.
Mm-hmm. Yeah, shock to her pockets too, it sounds like. Well, how are the assets divided if there is no spouse and then there's several relatives that could potentially inherit?
Again, if there is no spouse and no kids, then it goes to parents. So in that situation, you're looking at parents who would be inheriting if there's the laws of intestacy. However, if there are no parents, then it would go down to the siblings. That's the next level, would be siblings. But sometimes siblings predecease the decedent. So in that situation, then you need to go down the downline, nieces and nephews of the decedent. It's really creative the way that they've done the little chart. And you know what's funny? Most states are copying what we've done, but I've heard of situations where in Europe, for example, the laws are very different. Spouse doesn't get anything. She only gets, anything that her name is titled to it. So you can only imagine, you could have a very shocking situation where you're not inheriting at all. So super important to make sure you've got a will and a trust if you're looking to avoid probate, because that certainly, will is never enough. You always need to have a trust in order to avoid probate.
Well, you always hear people say they don't have family at all. What do you do in that case? Like, if they're like, I'm an only child, parents are gone, so there's no nieces and nephews, there's nobody.
I've seen situations where it goes to a charity, some
Okay.
sort of a nonprofit organization. And ironically enough, we get a lot of nonprofits calling our office to give us brochures and pamphlets and
Mm.
information so that we can take care of that type of situation and say, hey, what about the Wisconsin Humane Society, or what about the American Cancer Society? There's so many nonprofits out there. The Greater Milwaukee Foundation is a big one that many people do donate a lot of money to. In fact, I had a client who donated almost 1.5 million to this
Wow.
nonprofit charity, and it happens all the time. That's how these charities these nonprofits are able to function and continue doing good deeds. So it goes somewhere. And unfortunately, if you died, left it where there's nobody left in that situation, then it would go to the state of Wisconsin. So definitely make sure you've got a will.
Yes. So if minor children are involved, what kinds of issues can arise when there's no will in place?
Well, the kids will fight over assets. And unfortunately, when they're minors, what happens is there's a guardianship that's triggered, and that is so time consuming. It is very expensive, and it can be quickly avoided by making sure that you designate guardians in your will documents. Anybody who has a small family, children under the age of 18, should 100% have a will at the very minimum. I had a situation where this couple was driving home from a uh, a basketball game, and unfortunately, they both died. It was a drunk driver that hit them, and they both ended up dying at the same time. They had 5 children, all under the age of 18, and we had to go through guardianship proceedings for every single one of them. And then the fight started. One aunt wanted the kids, then the other aunt wanted the kids, then the other aunt. I mean, it just became a circus in court.
Hmm.
It's really important to make sure that if you have a young family, you're taking care of that family. Just like you purchase insurance for the what if, make sure that you have a will in place for the it's happening, we're all going to die.
Hmm. Yeah. We talked about where your things would go, but who takes charge of the estate when nobody has been named to handle the paperwork or the legal process?
Yeah. So what happens is there's a personal representative that's nominated typically in a will, but sometimes if you die without a will, then you have one of the people that's inheriting, that's an heir to the estate. They would step up, sign the petition in order to go to probate and be appointed as personal representative. Um, Again, Wisconsin has priority over who gets it and who, there's the laws of intestacy. We know it's very clear who's going to get it in a situation like that, because there's a chart in place that says, if not this, then that. If not that, then this. And the personal representative is usually someone who's blood related. And if you can't find or get anybody to do it, then the state of Wisconsin will appoint through the courts, through the probate courts, a personal representative to act on behalf of the estate if there's nobody willing to step up. I can't tell you how many times people say, "Well, I can't do that. I don't have time to do that." Well, you're going to get 2% if you do end up acting as personal representative, but people know how much work there's involved and they just don't want to do it. So they just pass it off to somebody else that is willing to do it. And the other big thing is here in the state of Wisconsin, if you don't live in Wisconsin, it becomes a little bit more complicated to act as personal representative. You're going to have to obviously appoint a resident agent to act on your behalf if you can't. And marshaling assets is another thing that can get very complicated. So it does make sense to choose a personal representative that lives in Wisconsin. That's really a smart idea. If you live in Wisconsin, choose somebody that lives in Wisconsin, and preferably somebody close by, obviously somebody you trust and know and love and know that they're going to do the right thing.
Well, family homes are often the largest asset that people own. And so, what happens to a house when the owner dies without a will?
Well, again, it depends. It depends how that property is titled. So if you have a situation where you have husband and wife, okay, and husband didn't get a will, say husband's the one who passed away.
Mhm.
If the property is titled in both of their names and it's got, the husband and wife language, it's safe. It's safe. Um, but if it just has one person listed on the title, then we got a problem. You're going to have to, at that point, go to probate in order for the asset to go to the next of kin. So some people like to use transfer forms, their transfer upon death forms. And that's something that our office can do. We do them all the time. There is a real estate transfer return that needs to be done with the TOD form. And they're pretty painless and quick to do, but it also designates upon the death of the owner of that property, then it would benefit the next people in line, and you can pick and choose who you want. But with these transfer on death deeds, I can't tell you how many times, you've got fights between three kids. So you have a situation where one of the kids wants to keep the property, the other two want to sell it. And then you've got the kid who wants to keep it to try to purchase it at a really low value. And then the other two are like, now, wait a second, we want fair market value. And then, the one is digging their heels and saying, absolutely not. I'm going to buy it at this price because I put this much into the property. In that situation, you're just going to end up in court. So honestly, the best way to handle, I don't think a transfer on death deed works unless all the kids are going to be okay. And of course, everybody says, my kids are never going to fight. My kids are never going to argue over this. Let me tell you, when it comes to money, anything is possible. I always say it's just easier to put it into a trust. You name one trustee and that person quarterbacks the whole thing. They sell it. They don't ask questions. They sell it at fair market value, which is going to be the fair thing. And that's what they're required to do as part of the trust, is sell it at fair market value and not try to buy it from under their sister and brother. So in that situation, I always say a trust is best.
Obviously, we mentioned money as when we start to see these family disputes surface, but is there anything else that tends to surface when there's no written plan spelling out someone's wishes?
I've seen people arguing over sentimental things. They're arguing over the coin collection. They're arguing over mom's diamond ring. They're arguing over furs and, just really tangible personal property items. It's just the sentimental stuff that, there could be a situation. And then you have blended families where in a blended family situation, you know, you could argue, well, this is mom's wedding ring and now it's being given to children who are stepchildren and, those kinds of situations. I think it's always best, put it in writing. We can take care of your will. We can take care of your trust document. We can take care of all your POA documents and just get it done and over with. And that way you just don't have those arguments. Eliminate as much as possible. Death is so emotional as it is. And to put that burden on your children and let your children duke it out, that's just not fair. And it's just, do the right thing. do the right thing, get a will, get a trust, and call our office. We can help you.
Well, as we wrap up, how difficult is it to create a basic will before any of these problems become someone else's responsibility?
Well, I mean, again, it's not difficult at all. It's just getting that person into our office in order to do and create it. Getting someone like me who's experienced. I got 30 years experience. You just can't beat that. And I've obviously used it to my advantage because I've seen so much in my 30 years of practice, and I'll put scenarios in there that someone may not necessarily realize that they need to do. One of them being a disinheritance clause. I can't tell you how many times, people are like, well, I didn't want so-and-so to benefit, but now we're in court because that person's contesting the will and they're making arguments that they're entitled to their half, or whatever the case might be. If you have had an estranged relationship with that child and you don't want them to inherit, there's magic language that needs to be put in there. There's also really important to put language in there for guardianship provisions for those young children. I can't tell you how many times people try to, cook up these documents on their own. They make mistakes. They're missing witnesses. They're missing a notary. It's a hot mess. Let a professional handle it. We can do that for you.
Well, thank you so much, Georgia. As always, this has been an informative conversation.
You're welcome.
Well, that is it for today's episode of Law for Life with Georgia. To learn more about attorney Georgia Konstantakis and Konstantakis Law Office, LLC, visit konstantakislaw.com. Thank you for listening, and be sure to subscribe, share, and leave a review if you found this episode helpful.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.